I call the Honourable David Parker.
Thank you, Mr Speaker. The Labor Party is supporting the Maritime Transport Bill to Select Committee. I want to focus in particular, sir, on the changes to the law that enable New Zealand to accede to the changes to the 1996 Protocol, which is the convention, which amends the Convention on the Limitation of Liability for Maritime Claims. Sir, there are two aspects to that are important. One is this bill enables the New Zealand Government to accede to the 2003 Protocol on this, which leads to the establishment of an international fund for the compensation for oil pollution damage, which originally started in 1992. But this change, which has been open to New Zealand for some time now, enables New Zealand to join this other fund, and it's paid for by a levy on oil importers into New Zealand. They are charged a levy. That levy goes into this international fund, which is a bit like an insurance fund, and then if there's a big oil spill our way, then that fund can be drawn upon in order to deal with the consequences of a major oil spill. And so it's very appropriate that New Zealand protects itself in that regard. We hope we never have to call upon those sorts of things, but one only has to look at some of the terrible consequences that have dogged parts of America for decades since the Exxon Valdez went down off the American coast, and you realise how terrible the consequences can be if you have the foundering of a major oil tanker. Sir, so that's good, and that's one of the reasons why the Labor Party is supporting this to Select Committee. The second aspect, as the prior speaker mentioned, is that it also enables New Zealand to take the steps that are necessary to exclude ourselves from some of the limitations of liability that apply to other forms of carriage of goods at sea. Unless New Zealand changes its rules and makes reservations that exclude the limitation of liability that otherwise applies, so unless New Zealand takes an active step to remove the limitation of liability that currently applies, the New Zealand government is limited in its ability to recover costs in respect of the consequences of other vessels that founder on our coastline. And this is a very real issue which was encountered in New Zealand as a consequence of the grounding of the Rena. Now, the explanatory note and the departmental disclosure statement and the regulatory impact statement all variously mention the Rena, but none of them make explicit that one of the problems with the Rena is that New Zealand hadn't done what it could have done by then to have removed the limitation of liability, which meant that there were limits on the amount that the New Zealand government could recover from those at fault for the Rena disaster, and effectively more of it had to be borne or potentially borne by the New Zealand Crown. Now, I can't remember, because it's quite a while ago now, what the final amounts were, but that was in the Rena founded on the 5th of October 2011, and when it hit the Astrolabe Reef, it subsequently broke up and it released about 2,500 barrels of oil, about 400 cubic metres of oil, and there was also containers went overboard, and the contents of those containers ended up in the sea as well. And the ability of the New Zealand government to sheet home the cost of that remedial work was limited by the then limitation of liability under the International Convention, which, because this legislation had not been passed, the New Zealand government hadn't been able to remove the limitation of liability. And it was a criticism that was made by the media and opposition parties at the time that if it had been acceded to, if we had acceded to the changes to that treaty earlier and we had enabled at law the New Zealand government to remove that limitation of liability, then the position could have been different. Now, sad enough that that happened in respect of the RENA, but you have to ask yourself, if that was in the 5th of October 2011, why it is that it's taken 5 years since that event to bring this legislation to Parliament, because it was evident at the time of the RENA disaster that this problem needed to be fixed. Now, luckily, there hasn't been a significant foundering of a large cargo ship off the shores of New Zealand since then, and so we haven't been adversely affected by that in the intervening period, but we could have been, and it's only a matter of luck that in the period since the 5th of October 2011, when the RENA grounded, and now that we haven't been faced with a substantial claim where the government's ability to recover compensation from the owners of the vessel that caused the environmental damage, had that occurred during this intervening period, the New Zealand government would have been hindered in its ability to do the right thing. And I can't see why it's taken that long to get this into Parliament. It's not a particularly long bill, as others have already said. This also covers drug testing. The total bill is 25 pages long. It's not a large bill. Significant part of that relates to the drug and alcohol management plans. Looking at that, those go for about 5 pages. The explanatory note and the index sections are about 10 pages of it. So, the relevant provisions that the Minister of Transport, if he spent less time looking in the mirror and more time looking at his papers, and I know that he's from down near the Astrolab, and I don't know whether that's where he got the idea of the Brill cream, but I know this is a cruel contribution, but I'm sure that your ego is strong enough to take it. Mr. Speaker, the Minister of Transport should have had this in Parliament years ago. And I'm looking forward to a contribution from the National Party to explain why, given that it was evident in 2011 that we had a gap in New Zealand's law that meant there was a limitation of liability as to how much we could recover from an overseas owner of cargo ships that foundered in New Zealand waters. And some people can never be. I'm actually very easily made happy. I'm a very happy person, but I'm disappointed at the slackness of the government and the minister in not bringing this to the House to cure this problem that was so publicly aired in 2011 following the foundering of the RENA, sir. Mr. Speaker, I'm not going to spend much time on the drug and alcohol testing provisions. I agree that they're necessary. I agree that technology's improved in a way that enables those testing regimes to be more practical than they used to be. And I also agree with the last speaker that the tragedy that we had in respect of the balloon, which burnt and then crashed to the ground following collision with wires, may have been avoided. We don't know that it would have been, but may have been avoided if we had those testing arrangements in place earlier. Sir, my main, one of the questions I think that does need to be asked by the Select Committee is why it is that there has been this delay in respect of the empowering provisions that enable the changes to the protocol to be brought into effect, both in terms of the oil spills for oil tankers, which is a different thing from the cargo ships, but also why have there been the delays in respect of getting rid of this limitation of liability in respect of cargo ships. And I'd also be interested to see a timeline as to how long it's going to take once this legislation is passed for those changes to be brought into effect in practice through the changes that are then made to New Zealand's participation in those international agreements. Thank you, Mr. Speaker.